Hello, and welcome to Thompson Hine's webinar, Government Procurement and Trade Pitfalls Across the Supply Chain. This program was originally broadcast on July 11th, 2017. We're adding a little introduction here because we missed a couple of moments of the recording of the session, but we will get you started and cut to the webinar itself in just a few moments. My name is Randy Miller, and I'm going to be introducing the speakers that you will hear today, as well as providing you some information as to the format of the webinar that follows. Our speakers, we have two of our partners from our government contracts practice, Tom Mason and Chip Purcell, and then we have two lawyers from our international trade practice speaking. That will be Mark Lunn, partner, and Brent Connor, senior counsel. As we launch into the program today, we will get to hear Brent Connor starting with a framework of what contractors should be looking for as it relates to government procurement. This will cover a variety of legislative and administrative frameworks that contractors need to be aware of to make sure that they are compliant. Afterwards, we're going to talk about the Trump administration executive orders for Buy American and Hire American, followed up by a case study example of things that you can think about for your organization. And then finally, we will take a look at some enforcement examples of what goes wrong when compliance is not followed for these legislative frameworks. If you have any questions, there's contact information for all of our speakers at the end of the presentation, and feel free to contact any one of those speakers. Thank you very much for your participation today, and we hope you enjoy the program.
Agencies that typically administer those statutes that have domestic sourcing requirements that help or that authorize the agencies to award grants for funding local projects. Turning to the next slide, slide 4, these are the typical situations where a government contractor or any business for that matter is going to run into domestic sourcing requirements. Obviously, if you're doing business with the federal government as a prime contractor, you're going to be concerned with domestic sourcing requirements. If you're a subcontractor, everyone needs to bear in mind that these requirements flow down to subcontractors at every tier, so you have to be aware of that. And then if you're participating in one of those local federally funded projects, like an airport improvement project or a transit project, you're also going to be confronted with domestic sourcing requirements if they're receiving funds from the federal government. Country of origin is another issue that contractors have to contend with when considering domestic sourcing requirements. Look, in order to determine whether or not you're compliant with domestic sourcing requirements, you're going to need to know what the country of origin is for each of the items or construction materials that you're offering to the government. Now, the test for this analysis is substantial transformation. Hopefully everyone's familiar with that, but just to remind them, it's essentially where you look at the articles or the components that go into an end item. You look at the process that is required to form the end item, and then you determine whether or not there's a completely different name, character, or use for the end item compared to the components. That's known commonly as the substantial transformation test. It's used both in customs analyses as well as domestic sourcing compliance analyses. Keep in mind that that's typically the test for determining whether or not items come from a free trade agreement country where free trade agreement country products are allowed. But for U.S. products under the Buy American Act, it's only part of the test. They have to be manufactured in the United States, but there's also more to the test for qualifying a domestic end item under the Buy American Act. So let's drill down a little bit on Buy American Act specifically. Contrary to what most people believe, the Buy American Act does not completely foreclose the acquisition of foreign items. It's a preference for domestic items, and we'll get to that a little bit later. But keep in mind that it's going to apply basically to any sale of supplies, any sale of construction materials to the government, and also for contracts that exceed the micro purchase threshold, which currently is at $3,500. So there's a two-part test if you turn to slide 7 with regard to qualifying domestic end items under the Buy American Act. There's the manufacturing requirement, and essentially if you can meet the substantial transformation test, then you can say that your item's manufactured in the United States. However, for domestic end products, you have to meet what's known as the 50% rule, or the cost component test. And that's where the cost of domestic components exceeds 50% of the cost of all of the components. There is a break here, though. If your item is what's considered a COTS item, and we'll talk about exactly what that is on the next slide. COTS item is a commercially available off-the-shelf item. So if your item fits that definition, you're not going to have to contend with the 50% rule. You just have to make sure that your item meets the manufacturing part of the test. Keep in mind, though, all right, so I'll back up for a minute. To be a COTS item, you have to either offer your item for sale to the general public, or that it's an item that the general public typically uses and purchases. Keep in mind, however, though, once you start modifying a product to meet specific requirements of the U.S. government, it no longer is going to qualify as a COTS item. So there are exceptions to the Buy American Act. There are public interest exceptions that have come up from time to time. That exception often melds or bleeds into the unreasonable cost or the non-availability exception. Non-availability would be an obvious exception as well, where the items aren't available either in an acceptable quality or sufficient quantity. And then with regard to unreasonable cost, this is where foreign items would be factored into an acquisition or an evaluation of offers. If there is an offer that involves foreign items, the contracting officer will add 6% to the offered price and compare that to the lowest domestic price. If the domestic price is more than 6%, is more than the foreign item offer with that 6% factored in, then the cost is unreasonable, and the award can be made to the offer that includes the foreign items. For small businesses, if that's the lowest domestic offer, then it's a different factor. It's going to be a factor of 12%. If items are being resold in the commissary, you don't have to contend with Buy American Act, and also if the acquisition's for IT that's commercially available, you don't have to deal with Buy American Act either. All right, moving on quickly to Trade Agreements Act. Just keep in mind that the Trade Agreements Act is essentially a waiver of Buy American Act requirements for products from countries with which the United States has entered into a free trade agreement. We've listed the typical examples of countries under free trade agreements at the bottom of page 10. So the vast majority of countries or products from countries qualify here under the government procurement agreement with the WTO. And then there are the free trade agreement countries themselves, like NAFTA countries, CAFTA. There are also bilateral free trade agreements like the U.S.-Israeli free trade agreement. We have one with Morocco, Oman, etc. There are various ones. And then under U.S. policy and legislation, there are also there's preferential treatment for products from least developed countries as defined by the U.S. Trade Representative and certain Caribbean Basin countries. So all of the products from the designated countries are going to receive equal consideration with domestic offers. There are parameters, though, if you turn to page 11. The preferential treatment for products from free trade agreement countries only kicks in if the estimated value of the acquisition at issue meets the threshold amount set forth in the applicable free trade agreement. If the estimated value is below that threshold, then there's not going to be any preferential treatment for the foreign country's products, and it will only be an acquisition for essentially for U.S. items under the Buy America or Buy American requirement. Turning now to slide 12, the Buy America requirements. This is essentially a a basket where a number of other domestic sourcing statutes falls, and they typically involve transportation projects, as I mentioned before, that are federally funded. But keep in mind that other statutes and other projects might be covered as well. I know that there are some broadband internet projects for rural areas that have domestic sourcing requirements. So other industries might be captured. But essentially, these programs are administered by the agency overseeing the grant or the funding for the project that's carried out on a local basis. The general rule is that no funds will be obligated under the grant unless all steel, iron, or manufactured products used on the project are produced in the United States. And very often, this rule extends to components of those projects as well, so you have to be aware of that. And then the typical waivers for Buy American requirements will usually apply here, but there is no free trade agreement there's no free trade agreement exception for items from free trade agreement countries. That will not be a consideration under Buy America. All right, turning next to Berry Amendment. This is an easy one because it affects DoD contracts only, and it only applies to the items that we've listed here on slide 13. And again, it's going to require that each of the items and their components are wholly of U.S. origin, but there are some typical exceptions as well. For instance, the acquisition threshold is a little bit higher for Berry Amendment, and any acquisitions outside the United States will not be covered as well. So that gives a basic overview of the statutes that apply here. And at this time, I can turn it over to Mark Lunn, who will continue with the presentation.
Thank you, Brent. Yes, as Brent said, he went over the basic laws that are involved in this area, but we also have these things called executive orders out there. And I just want to talk for a minute about what's the practical implication of the executive order that President Trump signed back in April called Buy American, Hire American. As you'll see on the slide, in both the circumstances we're talking about buying American goods or hiring Americans, it talks about consistent with the law, enforce and administer the law. The executive order doesn't and can't change the laws that we have on the books. They don't change the fundamental aspects of the Buy American Act or the Buy America Act in any way, shape, or form. What it can do, and I think we will see this over time, is wherever there are areas of discretion, we will see sort of a thumb on the scale going toward domestic goods. And you'll see things, I think, maybe pushed up the line a little bit more. In areas where we could work things out in the past, I don't think it won't be as easy as it was. I've had examples with my own clients where they were selling foreign-made goods under a contract, and we had obtained a waiver for them, and the goods ended up on the construction site, and the construction manager said, "Nope, take them away. We can't use foreign-made products, produced in Thailand on this project." In those situations in the past, we've simply got our paperwork together, talked to the construction manager, and we're able to obtain, convince them that yes, these were acceptable goods and they had been approved and could go forward in the construction. It's those types of situations that in the past we were very easily able to resolve that concern me about what we can do in the future. And there's many areas like that. And when we talk about Buy America, the issue is often what is a subcomponent versus a component. That's not clearly defined in the statute, and there's some discretion there. So you may see a stricter enforcement of the administrator saying, no, that's a component that has to be manufactured in the United States, as to a subcomponent that doesn't. So those are just different areas where there is discretion that's available to the contracting officer, and where we might see a stricter enforcement than we have in the past. Again, it's not going to change the law. Next, I want to talk about some practical issues in this area. I mean, take for example, you're looking at an RFP. They want to purchase a product, or the government is asking to purchase a product, or it's going into a construction project that's funded by the government. Your company sells that product, and you want to know, are we eligible to sell under this? Are we able to make an offer? And along with the RFP comes this certification or some language that says, if you make this offer, you are certifying that you comply with the following rules. And you want to figure out, well, do my products comply with these rules? Where do I start from? First thing you do is start with the product. Some situations are quite simple. If a good is wholly of the manufacturer or production in the United States, you're good to go. But that's a very strictly defined thing. If it is coal mined in Kentucky or corn that's grown in Kansas, you're fine. But moving down the sort of production line, if it is a steel beam, when does that considered wholly of the production of the United States? The substantial transformation test doesn't apply in this situation. Generally under customs rules, if you take a steel billet and roll it into a hot rolled coil, that's substantial transformation and the good becomes U.S. But that doesn't apply under Buy America. Under Buy America, you have to have all of the steel making processes, including galvanization or coating, done in the United States. So what that means in the case of a steel beam is, if I'm selling a steel beam and I'm certifying that this meets the requirements of Buy America, I'm saying, I know what coil this steel beam was made from, and from that steel beam, I've got a mill test certificate, and it tells me where this steel was melted. So when you're from liquid steel on forward, if you galvanize steel beam, the galvanization has to be done in the United States. So if you can certify to that, you are eligible to sell that product into that under that contract. So that's the level of detail that you really do need to know. And in a case of steel, everybody knows it. There's easy traceability back to the heat or the melt, so they can do that. But if you are dealing with a manufactured product, things become more complicated. What I always, and I have had clients that sell foreign-made goods, and they sell a lot under government contracts. And when they call me and say, well, can I sell my HVAC unit under this contract, that the first question I always have is, where does the money come from? Who's administering it? Because the rules are different if you're dealing with Department of Transportation versus the Department of Energy, for example. So you got to know where the money's coming from. Then you want to know where the manufacturing is done. If, I say, okay, if you're dealing with an HVAC system and you're bringing in parts and components and just simply assembling them in the United States, that's not going to work by itself. However, if you're doing more than that, you're making the subcomponents, you're manufacturing here. It's something beyond mere assembly. Then where are the components coming from? Are the components U.S.? And what is the component in those situations? What's the value added in the United States that you have to calculate for Buy American aspects? Or are the components U.S. origin for purposes of Buy America, depending on which rules are applicable? So these are the types of things you have to figure out. Does it count as a U.S. product? If it does, then you're good to go. If it doesn't, and you're dealing with, again, something produced in Thailand, for example, next thing you do is say, well, I'm selling this to a highway administration, so Buy America applies. It's a manufactured product, primarily of steel. The probability is you cannot sell that product under that contract. There are waiver applications, but it is very, very strictly enforced, and the chances are minimal that you're going to be able to sell. But if it's Buy American, let's say you're selling it to the Department of Energy, then you have more of a chance. You want to know, does it come from a designated country? That means that country is a signatory to the World Trade Organization, government procurement agreements, or we have a free trade agreement with that country. So you say, okay, it's produced overseas, or it's produced in Canada, for example. NAFTA applies. I can sell under that. So then you're good to go. But let's say if it doesn't apply, you're, again, producing in Thailand. Thailand's not a designated country. Can you do it? Then you want to look at the terms of the contract. What are they selling? And is a comparable product produced in the United States? If it's not, then you can request a waiver. And, that waiver is approved. It does generally, though sometimes contractors will push back a little bit, apply, going forward until somebody complains or says, no, we do produce this in the United States. So I have had clients that sell HVAC systems produced overseas, and in those situations, we have been able to sell under DOE contracts or RFPs. The Transit Federal Railway Administration, however, we couldn't. So it really depends on where the money's coming from, what the product is, where it's assembled. So those are the things generally that you need to look at in deciding whether or not your product is eligible to be sold to the government. And as I said, all these things come with a certification. So you're going to say, I'm going to sell my product, and it's going to be certified. And, Chip and Tom are now going to talk a little bit about what happens when those certifications aren't accurate, or you make mistakes. So I'm going to pass it on to Chip, who will talk about sort of more the enforcement areas.
Thank you, Mark. We're going to talk about a number of enforcement mechanisms that both the government and, in some instances, private individuals have against contractors for violation of domestic sourcing certifications. And the primary of these is the False Claims Act. There are two elements to False Claims Act, both civil and criminal. I'll talk about the Civil False Claims Act first. There are four elements to a false claim action. The contractor submits or causes to be submitted a claim for payment. Contractor's claim is false or fraudulent. Contractor knew that the claim was false or fraudulent, and the falsehood was material to the decision to pay the claim. So each of those elements have to exist for a successful False Claims Act action against a contractor. One thing to think about is, well, what is a claim? What does that mean? So claim is any kind of request or demand for money or property that's either presented to the officer or employee of the United States, or, and this is important too, made to a contractor, grantee, or other recipient if the government paid for or is obligated to reimburse the claim to the contractor, grantee, or recipient. So this is how, looking at the supply chain, subcontractor passes on to its prime contractor an invoice for payment for materials supplied under a government contract, is certifying that those materials are compliant with whatever the domestic sourcing requirements are. That can create a false claim. So from a prime contractor's perspective, there's the need to be looking down at the supply chain to know that your suppliers, subcontractors are meeting whatever the domestic sourcing requirements are, and conversely, looking up the supply chain, I'm a subcontractor or supplier, I'm aware of what those requirements are, and when I provide a product to my prime contractor, I know that those things are compliant. The slide hits on damages. There are two elements to damages: treble damages, so whatever the amount of damage the government calculates would be automatically gets tripled. Add on to that a penalty for each false claim of a range between $11,000 and $22,500. So if we've got an instance where you've got individual invoices and each of those invoices involves a false claim, the government can tally up all of those invoices and do the math. I've got 1,000 invoices at somewhere in that range, plus treble damages. It can add up to a rather lofty number. We often see with False Claims Act actions is that they're initiated by an individual, a whistleblower, a disgruntled employee, someone with knowledge that there's been some violation of the False Claims Act. That person, we call that person a relator, a qui tam relator. So the way that the law works is that the key tam relator files a complaint under seal. The company contractor that's alleged to have violated the act doesn't see it initially; it's under seal. At the same time, the relator provides to the Department of Justice information on the substance of their false claim allegation. The Department of Justice has 60 days, often bleeds into a longer amount of time, but 60 days to evaluate whether or not they're going to intervene and assume responsibility for the action, or decline to intervene and allow the key tam relator to take on the action. And there's, depending on whether or not the government intervenes, the private party stands to profit on any kind of a settlement or conviction or guilty plea emanating from a false claim in a range between 15 and 30%. So they can be rather good things for a relator. Next slide, please. So we've got definite, and obviously there's an element of knowledge involved in a False Claims Act. No, we talk about it has to be knowingly provided. So it's both actual knowledge as well as deliberate ignorance or reckless disregard, but there's no specific intent requirement there. And with false claims, we generally see different kinds of false claims. And I think, again, particularly in this context where we're talking about domestic sourcing requirements, it's sort of important to think about how those things might occur. We can have a direct false claim, which is a knowing false representation that causes the government or recipient of government funds to pay more than it would have in the absence of the misrepresentation. So I'm a prime contractor. I submit an invoice to an agency for services I didn't actually perform. Second kind is express false certification. A contractor expressly and specifically certifies compliance with a required contract provision, statute, regulation, or government program, pardon me. So here, I've got a contract that requires me to certify that I'm BAA compliant, I'm TAA compliant. I knowingly submit products that are not BAA, TAA compliant, but I certify that I do. I've got a false claims situation on my hand. Third kind is an implied false certification, which would be an instance where the contractor is liable under the FCA based on a contract breach or an implied responsibility, even if the contractor isn't certifying compliance. So I'm submitting an accurate bill for a construction project, but I have failed to comply with some sort of a contract term. Last kind is fraud in the inducement, where false representations made by a contractor to induce the government to enter into a contract that it wouldn't have entered into otherwise, absent that misrepresentation. I am going to supply you BAA, TAA compliant products, Mr. Government Contracting Officer, so please award me a contract. That could be the instance for a False Claims Act violation there. Next slide. And the other aspect to this is beyond the civil is the Criminal False Claims Act. And often you'll see the government pursuing remedies under both statutes, and Criminal False Claims Act violations can involve guilty plea on the part of individuals or a company, as well as fines. Go to the next slide. We've listed out various enforcement mechanisms that the government will have in instances where there have been violations of any contract term or regulatory requirement, statutory requirement, including BAA, TA compliant. We talked about False Claims Act actions. Along with that, another significant hammer that the government carries is suspension or debarment. The government can suspend or debar a contractor both for conviction or guilty plea or evidence that suggests that contract terms are being violated. So if I'm a government contractor, both of these government remedies are significant ones because they'll basically cut off my ability to do business, and the government also looks at, as part of suspension and debarment actions, whether they're going to allow contractors to continue performing their current contracts. So a significant remedy for the government. Next down the list, we have contract termination for default. The government, retains the unilateral right to terminate a contractor for default. So again, the government has some knowledge that the contractor is violating the terms of a contract, included in its remedies is the ability to terminate that contract for default, which allows the government then to go out, reprocure whatever good or services that it's buying, and go after the contractor who's been defaulted for excess reprocurement costs. So again, it can be significant financial penalty for a contractor. Government claim for costs. The government, again, has the contractual right to seek equitable relief in the form of contract costs from a contractor. There's an administrative process that goes with that, but if the government thinks that it's out of money based on some sort of a failure to comply with BAA, TA requirements, it can go after the contractor for those costs. Negative past performance. I mean, of these, probably not the most significant one, but something to think about. If you've got a contracting officer who's not very happy with the way you've been complying or attempting to comply with BAA or TA obligations. Audit investigation. The government has the right under most contracts to come in and audit performance. So here, to see if you're compliant with BAA, TA requirements. One of the cases that we're going to talk about later on, there was a finding by a district court that the contractor was doing a poor job of maintaining records related to its TA compliance. So government auditor or investigator could come in during performance to take a look to see whether in the government's estimate, you've got adequate systems, processes, records to show that you in fact are compliant with those domestic sourcing requirements. The last one here, mandatory disclosure, which is a few years old now. There's a FAR requirement that if you've got credible evidence of a violation of federal criminal law or the False Claims Act, you've got to go ahead and report it to the government, to the IG and the contracting officer. And we'll talk again about some of this, how that may impact the potential outcome of a instance where you've got a violation of a TAA or BAA requirement, but again, can be a significant remedy for the government. So I'm going to hand it over to Tom.
So I want to pull together a couple of things here, if we can. First of all, we've had a statutory lay down. We've seen some analysis as to how to plan to deliver under a contract. We've taken a look at some of the enforcement mechanisms, and so my question is, who is responsible for this? And we put this slide together that says everyone has a duty to report credible evidence of fraud. And because everyone is everybody. It means the government contracting officer, the government employees. It means the contracts manager, contractor employees. Everybody has a duty to report. So if we have a duty to report, we need to think about how to get everybody informed so that we can be prepared to perform a contract and comply with these statutes and know how to give the government what they're seeking and what they're paying for. And so government officials report. We don't want the government officials, if we're a contractor, to be the first one to report, because they're going to report to the suspension and debarment official of their agency. The remedy likely there is you get fired, suspended from contracting, or debarred. Contractors have to make mandatory disclosures in accordance with the provisions of the FAR, and if they fail to make these disclosures, contractors can get debarred for failing to disclose. And individual employees are also on the hook. They're required to report on the company hotline. And so we start with this idea that in order to successfully perform a contract, everybody has a duty to ensure that the contract is performed decently, in good order, in accordance with the law, in the terms and conditions of the contract. And so how do we deal with fraud? We don't necessarily go around and say in our company areas, hey, we're dealing with fraud today, so let's put on our fraud hats and our fraud prevention techniques. But fraud is something that we can detect and we can avoid. And so we start with the point of education, training, and inspection, because this will help us to identify the problem areas in our contract performance. So, for instance, if we're dealing with delivering products that have to be compliant with the domestic preference statute, one of the easiest areas to take a look at is the documents that go with the product. As Mark said, if we're delivering steel, he spoke about the test reports, he spoke about the trailers, the documents that go with the product. If we can get a look at those documents, it will be very evident very quickly whether there's been redactions, whether there's been copies, where there's documents that have half the columns blocked out. It would be very quickly that there might be an issue with that. And so as a contract manager, that gives you a heads up on where to look. So we educate what's required in the contract. We train where to look to see to make sure that we're delivering compliant performance, and then we have to surveil. We have to inspect to make sure that we can identify our performance as being compliant before we submit that invoice. And so the next point I want to make with respect to education is that there are 4 basic remedies that the government manages and the government will harmonize: criminal, civil, contract, and administrative. Some clients call and say, well, I heard about this case with this other company, and it looks like that case is going to be it was handled differently than my case is. And that's because the government manages the remedies in a different manner. Now, the criminal remedy is one that imposes fines and often imprisons individuals. It's not that often that we see a criminal charge brought against a company, but it's generally a remedy the government uses against a bad actor within both the government and the contracting community. The civil damages are where the government gets restitution. It gets a damage and it gets a mandatory fine. The damages are designed to reflect the harm that the statutory violation has caused the government. So if they're buying a domestic piece of engineering equipment and they find out that it's not domestic, it was made in a different country, there's some measure of damages that the government will seek for that. Contract remedies are simply read the contract. And if you're required to do something on the contract, then the contract calls for specific remedies for that noncompliance. It could be a termination for default, convenience, it could be a corrective action report, it could be a deficiency notice, they could issue a show cause to correct why that you shouldn't be debarred, they could accept the delivery at a reduced price. There's many things that can be done as a matter of contract law to remedy the situation. And it's good to know, if we're the contractor, what those remedies are and what we can propose to the government when we find ourselves in a situation where we have to address a noncompliance. Administrative are the remedies that sound the best, but they're the worst. Administrative remedy, if the government says those words to you, means they're going to fire you by debarring you from contracting forever, or they're going to suspend you until you get your systems in place such that you can be a responsible contractor. The only rules that really apply across the board for government contractors is they have to be deemed responsible. They have to be deemed financially responsible and technically responsible to do the job. And if you're not going to be able to deliver domestic preference items in accordance with the statutes, you will be often determined to be not responsible, and the government will then take an administrative action. And so the government will use all these remedies, and they're going to harmonize a government response to a situation. For instance, we had a situation where we were representing a subcontractor. The CEO of the prime contractor gave the government contracting officer a $3 million bribe. The next day, after the raid and the arrest, the contract was terminated for default, the contractor was debarred, and the contracting officer was arrested for accepting a bribe. Those remedies took care of the case. The other remedies weren't required, and so the case was wrapped up very quickly using just the administrative and contract remedy. The government will talk in terms of its writings, in terms of its need to protect the taxpayer, to ensure performance is compliant for the U.S. agencies that are involved, to make sure they get the right kind of products so that it can be supported through the supply chain and life cycle resupply, to preclude reoccurrence, and to obtain restitution. And so if we talk about these remedies just briefly, the two biggest are civil false claims damages and administrative remedies. Whenever we have a violation of a domestic preference statute, it's typically going to be handled with a civil false claims perhaps an investigation will start with the issuance of a CID. There'll be penalties and damages that would be a measure of restitution for the defective product. There also can be some administrative remedies that would go along with that. The one that we see most often is the administrative agreement, whereby the contractor will be required to negotiate an administrative agreement with the government, and the agreement would require the contractor to pay for the government's monitoring of their performance to ensure that there's no recurrence of a problem with the supply of product. And I want to make sure that that everybody understands this applies to all levels of the supply chain. You don't get a pass if you're a second-tier subcontractor. And even if the clauses aren't in your contract, you don't get a pass. You will be considered to be able to comply with these statutes because they're on the books and they're a public record, and that's what's required by the prime contractor. So if we go to the contract remedies, this is one I think that we need bear some attention. Breach of contract is easy. The government can deny any request for equitable adjustment or claims that we have submitted as a contractor. The government may assert affirmative claims. The government can terminate for default, but more often they terminate for convenience or for convenience, and they can do that for any reason or no reason. They can suspend payments. They can accept the good and reduce costs. They can terminate for default and then require reperformance of another contractor and charge back the difference. They can void the contract, and as I mentioned, they can do all the other administrative things like issuing deficiency notices, show cause notices, and the like. I think the contract remedies are very, very important because often this is the remedy that hits first. As the government learns about the case, often the agency will be taking remedies under the contract for this situation. And the point I want to make is that for the civil and the criminal remedies, it's the Department of Justice that drives the resolution of those remedies, and for the contract and the administrative remedies, it's the agency that deals with this. So our point here as we begin to talk about the case studies and the actions that we're going to study is that the government's going to harmonize these four areas of remedy, and they're going to make decisions based upon what's best in that case. And so it can be any one of the four. To the extent that we're prepared to deal with those four remedies as contractors, the better we're going to be able to guide the government and teach them a way that would be a good and effective resolution of the case. If, in fact, we can be the first one to disclose of the government contractor team, and if, in fact, we can provide a resolution to the problem, we have gone a long way in getting the government to come alongside of us and let us clean the situation up so that we can continue performance after we have remedied the problem. Would like to, at this point, I think, turn the program back over to the rest of the panel. Chip, I think, will lead off and talk about some recent enforcement actions.
We've got two slides of some more recent cases involving BAA, TA, non-compliance. I think that to just pick up on Tom's point about the government's harmonization of its remedies, I think talking about these cases, I'm not going to talk about all of them, but I'll talk about a couple of them just briefly. It does show that harmonization and in one case, picking up on Tom's point about sort of a preemptive disclosure by the contractor and how that shapes the ultimate outcome. But starting on the top, the Novum Structures case, which is a few years ago, involved both civil and criminal action under the False Claims Act brought by the government for a BAA violation by the contractor. So there was a criminal action under the False Claims Act that resulted both in a guilty plea and usually a $3 million fine. I think about $500,000 of that went to a criminal. The remainder of the $2.5 million went to a civil False Claims Act violation. But going back to this issue about remedies, harmonization of remedies, as a result of this, the contractor was debarred and remains debarred today from doing business with the government. So, not only the short-term pain involved with paying these hefty fines, but the longer-term pain that came with the continued debarment, not being able to do business with the government. Contrast that with the second case, the Osser Americas case, which grew out of a voluntary disclosure. The company realized that it was violating a BAA requirement in its contract related to foreign-made prosthetics products, resulted in only a $500,000 fine. Not insubstantial, but compare that with the first case, certainly much better. One of the things that the Osler Americas company did was demonstrate that once it had determined that it had violated the BAA requirements of its contract, it instituted a number of internal compliance policies, which included coming up with institutional sales sheets for its representatives about BAA compliance, as well as training for its management on what the BAA required. Going to the next slide, I'm going to skip over the CDW case and talk quickly about Capital Supply, which is an ongoing case. In looking at this, is a case that's been going on since 2010, and from what I can tell, continues to today. Came from a whistleblower action against a company that supplies products, office products to the government, mainly under the General Services Administration scheduled contract. And the allegation is that it's violated the TAA requirements of the scheduled contract. One of the issues that's come up here, going back to the remedies that the government has, is part of the litigation process. The government's come in and taken a look at the records and the procedures and processes the company has to track its TA compliance, and found that it was lacking. There really weren't any records to demonstrate that, and that's become a real impediment for the company in terms of prosecuting its case. I'll turn it over to
Questions. Q&A now, I think.
We'll address one last slide here before we go to questions, and not the topic of today's webinar, but there is a need, and I think everybody in the audience that works for a government contracting company knows that there's a very acute requirement to have a business ethics program, and so the only point that we wish to make here is that in our business ethics program, it's if we have the kind of company that provides goods and services that are going to be subject to these domestic preference statutes, then we need to make sure that we include consideration of these statutes in our ethics program. And so we just have 5 takeaway bullets for ethics, and we don't want to leave this to the government to enforce, and the government doesn't want to leave it to us to enforce. It's a team enforcement responsibility. And so we need to think about establishing a culture of compliance and meeting standards of conduct, which we would call the compliance with statutory, regulatory, and contractual obligations. We need to make sure that we have a program that would identify, report any type of indicator of fraud that would cause a reasonable manager to think that there was a problem with our domestic preference performance. And the last point is that this isn't something that we leave to C-level executives or compliance officers or contracts managers or contracting officer representatives. This is a responsibility of everybody that's involved in contract performance to make sure that our performance is not only compliant with the contract, but it's compliant with the statutes that are required under the contract. And so we would encourage everybody to think about their ethics program and take a look at the ethics program for the inclusion of these domestic preference considerations. And so I think, Randy, I guess we're ready for questions and answers at this point.
Okay, thank you very much. The first question we have is, domestic sourcing requirements are supposed to flow down from the prime to the sub, but under the Christian doctrine, if the prime fails to flow it down, can the sub be liable for non-compliance or just the prime?
Well, I'll kick off the response simply by saying that the requirements flow from the prime to each sub at any tier statutorily. And the Christian doctrine, I think, is really something that was created by the court to read statutory provisions into contracts where the contracting officer has left them out. So you have to look at this as 2 separate issues, really. I don't know if anybody else wants to comment, but I mean, the thing to remember is that statutorily, subcontractors at every tier will have to comply with the domestic sourcing requirements.
Yeah, and I think, I mean, I agree with Brent on that. I think it's sort of looking beyond what the Christian doctrine may or may not require to, okay, statutorily, regulatorily, you know, I'm in the supply chain. What am I obligated to provide? So there may be some disagreement about the government has failed to incorporate a particular clause, but you know, with this sort of domestic sourcing stuff, I think that may overcome any kind of Christian doctrine issue.
Okay, thank you. Our next question is, what if we are not sure of the country of origin of a particular component or item? Who can we ask?
You would go to, you would ask the whoever you're purchasing it from, and usually you can you will require, again, goes to the requirements flowing down, certification that it is compliant with whichever rules apply. Goods have to be labeled, and you have to be able to determine the country of origin of the goods, whether they're imported or produced in the United States. So you should be able to find it. It may not be as easy with some products as others, and you do have to know the rules of origin as well as which rules, procurement rules apply, so you know which standard to apply.
Okay. On a related note to that, if you have an item such as this, who decides if it was manufactured in the United States? Who's the body that just makes that decision?
Under the Trade Agreements Act, you can look at customs, now CBP, Customs and Border Protection decisions. So that's typically, sometimes you have gray areas. Clients come, you know, to us with questions like, I'm doing this processing in this country and this processing in this next country, etc. And I'm not sure what the country of origin is or where substantial transformation takes place. So in that case, we typically go to the customs decisions, and we try to find decisions that involve products that are similar to the product at issue. In some circumstances, we may want to file an inquiry, a formal inquiry with customs, and get a formal customs decision as to what the country of origin is when you have some of those difficult situations where processing takes place in various countries, and it's not clear, you know, which is the country of origin.
And there's, I think, beyond the more formal opinions, there, if memory serves, there's a more informal read, I think, that you can get from customs about country of origin issues too. There are different avenues if it's sort of uncertain that you can reach out to get some certainty from the government in terms of what is that I've got.
Exactly. Exactly. Yeah, you can get informal guidance as well.
They're advisory in the form of advisory opinions. And to my knowledge, you can search the ones that have been published, and you can seek one if there's not.
Right. Those are the decisions that I was referring to earlier.
That's right.
As we get to wrap up, we'll just have one final question. If someone can talk about what is the primary difference between the Buy American Act and the Trade Agreements Act?
Well, I'll just, you know, take a stab. I mean, look, the Trade Agreements Act, it operates as a waiver for the president to waive the Buy American requirements for products that are produced in free trade agreement countries. Hopefully that clarifies it for the person who's asking the question, but think of it as an exception for those countries with which we've entered into free trade agreements.
As well as countries that are members of the WTO or signatories to the WTO government procurement agreements, as well as the other ones that were mentioned.
The Caribbean Basin and then the least developed countries. Yeah.
Okay. Well, thank you very much. This is going to conclude our program today. I've got some information here on our presenters, and I'm going to be sending each of the attendees a copy of these slides. If you have any follow-up questions, please feel free to contact Brent, Tom, Mark, or Chip. And thank you again for attending our webinar today. Just one last shout out to let you know that we have a dedicated website for the government's trade initiatives and programs. It's trumpandtrade.com, and we have continual updates on the major platforms that the president has identified as trade issues, including China, Cuba, free trade agreements, Iran, NAFTA, Russia, and as new items appear, we are updating this website 2 to 3 times a week, and we appreciate it if you have the opportunity to either visit or bookmark it as needed. Thank you again for attending, and again, if you have follow-up questions, please feel free to contact any one of our presenters today.